Thanks for coming back. I'm David of David vs. Goliath, taking down corrupt tyrants. This will be a short video explaining and showing you what lawyers and attorneys won't tell you. What I'm about to tell you is kept secret by the profession. The fact of the matter, the governor and its agencies falls under the executive branch of government. The court system today, including the clerk of courts, are not judicial, but administrative pursuant to Texas statutes and 5 United States Code, the Administrative Procedure Act. Since they are not Article III or constitutional courts, they are administrative courts that fall under the executive branch and under the Administrative Procedure Act. In short, they are for-profit businesses. Secondly, why would anyone in their right mind even hire an attorney? The court and its officers can only interact with either a corporation, trust, or, quote, ward of the court, end quote, and cannot interact with a live human or people, except in a court of record in a common law venue, which is superior court. Under the corpus juris secundum, which means body of law, it explains what you are if you should ever hire or employ an attorney or lawyer. What is the corpus juris secundum? In the legal realm, it is an encyclopedia for the legal profession. Under Volume 7, Section 4, Attorney and Client, the attorney's first duty is to the courts and the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Clients are also called, quote, wards, end quote, of the court in regard to their relationship with their attorneys. Under 7, Corpus Juris Secundum, Section 4, Nature and Duties of Office, an attorney is an officer of the court with an obligation to the courts and the public as well as to his clients, and his duty is to facilitate the administration of justice. An attorney does not hold an office or public trust in the constitutional or statutory sense of that term. And strictly speaking, he is not an officer of the state or of a governmental subdivision thereof. Rather, as held in many decisions, he is an officer of the court, before which he has been admitted to practice. An attorney is not the court or one of its ministerial officers or a law enforcement officer. He is, however, in a sense, an officer of the state, with an obligation to the courts and to the public, no less significant than his obligation to his clients. Thus, an attorney occupies a dual position, which imposes dual obligations. In the next frame is the definition of, quote, wards of court, end quote, per the Legal Industry's Black's Law Dictionary, 4th edition. As you can see, it reads at the lower left bottom of the page that it is infants and persons of unsound mind. So, by hiring or employing an attorney or lawyer, you become a ward of court. And since obviously you are not an infant under the definition if you are reading this, what does that leave per the definition of ward of court? That's right. You are a person of unsound mind because you are unable to do for yourself and had to hire or employ an attorney or lawyer to take care of you and or your business. Here is something else I bet you didn't know that is very interesting. In 1950, the 81st Congress investigated the Lawyers Guild and determined that the Bar Association is founded and ran by communists under definition. Thus, any elected official that is a member of the bar will only be loyal to the bar and not the people. We now know why, on the 9th of December in 1945, the International Organization Immunities Act relinquished every public office of the United States to the United Nations. In 8 United States Code, Section 1481, stated that once an oath of office is taken, citizenship is relinquished. Thus, any state employee becomes a foreign entity, agency, or state. That means every public office is a foreign state, including all political subdivisions. Example, every single court is considered a separate foreign entity. Under 22 United States Code, Foreign Relations and Intercourse, Chapter 11, identifies all public officials as foreign agents. Federal Rules of Civil Procedure 4J states that the court jurisdiction and immunity fall under a foreign state. Any state agency that operates, quote, for profit, end quote, is not de jure, but de facto, and void of immunity, thus operating like any other publicly traded corporation as declared by the United States Supreme Court. This in Clearfield Trust versus U.S. 318, U.S. 363, 1943.